I'm Charles Nwasor. I'm the Director of Global Assurance and Advisory at Ensono. Part of my responsibility include enterprise risk management, compliance with regulatory requirements, our assurance programs where we take care of SOC reporting, industry certifications around security and privacy. We're also responsible for the global privacy program. As a service provider, Ensono is under direct obligation to comply with GDPR. We have European employees, we have European clients as well. So as a service provider, our obligation are two-pronged or is two-pronged. First, we are directly required to comply with GDPR because we have employees who we process their personal data in our employment relationship. And then secondly, as a service provider, we process data on behalf of our European clients. Well over 61% of US-based companies have not started implementing compliance with GDPR. And this is problematic because research by TrustArc, formerly TrustE, shows that these companies have not reviewed whether or not GDPR applies to them. And that's a problem because although it is a European law, the GDPR applies to all organizations that process the personal data of persons who reside in the EU, not just EU citizens, but those who reside in the EU. So the objective of GDPR, as you may know, is the protection of the personal data of natural persons. Such protections, as far as technology is concerned, requires the implementation of certain technical controls. First, around consent lifecycle management. In consent lifecycle management, the GDPR requires that you ensure proper disclosures and obtaining of consent, and that you document how consent is given. You have processes for maintaining updates or withdrawals of consent. And all of that should be documented and maintained, and you should be able to demonstrate at any point to regulators or any legal process that such process for consent lifecycle management is managed properly. Other requirements include technical protections, such as the use of data pseudonymization, cryptography, network security, proper access control and identity management. In addition to that, companies should ensure that in the way they design products and solutions, they ensure that data protection is engineered into the design process. For example, when you're doing requirements gathering and articulation, you should ensure that all aspects of the data flow are mapped and you apply the appropriate technical controls to safeguard the processing of data. The bottom line is that you should engineer into the process of developing products and solutions data protection by design. So you apply the necessary controls to ensure that any handling of the personal data of EU persons or anybody in general, that the appropriate controls are in place. Where data encryption is necessary and feasible, that should be factored into it. In the network security aspect, ensure that all aspects of a product or a platform applies the necessary controls such as firewalls and application whitelisting and other necessary controls. Third parties matter significantly. If you look at the ecosystem of any company, you have suppliers, you have clients, you have business partners, all of whom or some of whom may process personal data. And where that involves personal data of persons who reside in the EU, it is absolutely essential that in your legal agreements with such entities that you ensure that you transfer the liabilities or the required protections under the GDPR to such entities. Where it is clients, you must ensure that you define the roles and responsibility of the client as a data controller and of your service provider organization as a data processor. For those who provide services to you or products that involve the processing of EU personal data, you should ensure that such vendors are brought under your third-party risk management program and that you execute the necessary intake evaluations to ensure that their security and privacy processes meet the requirements that you have under the GDPR. The GDPR in the current business discussions is a significant concern, and it is really important that organizations go out and look to see if GDPR applies to them. So you need to evaluate your business. If you're a business-to-business organization or you sell to customers directly, if there are people or businesses that have European connections, you are likely to be under requirement to comply with GDPR. So the first step there is to check to see if GDPR applies to you. If it does, it is then necessary for you to review the regulation to see to what extent it applies to you and what technical, organizational, or process requirements that you have to put in place. For us at Ensono, we have done that first base review, and we understand that as a service provider with European operations that we are under obligation to comply with GDPR. To become compliant, we took a four-phased approach. The first of which is where we looked to discover how we handle personal data at Ensono, and also performed a gap assessment to see how our existing controls measure up to the requirements of the GDPR. The output from the study of how we handle personal data and the gap assessment help us into our phase 2, where we actually implement the necessary controls. For us, this will be a set of net new controls that will help us become compliant. In the subsequent phase, which is phase 3, we will do control validation. We'll bring in a third party to take a look and assess the controls that we've implemented to comply with the GDPR. And then finally, our objective is to ensure that we have a process in place to be able to demonstrate ongoing compliance with GDPR and to be able to provide documentary or substantive evidence to that effect. So, and that may include at some point a GDPR certification as soon as there is a certifying body in the US or in Europe. So from a policy and process perspective, some of the things that are required under the GDPR are not particularly new in the privacy realm. You know, the right to access records, the right to make corrections or request copies of your records. However, the GDPR requires that you allow data subjects the right to be forgotten. So where appropriate, the GDPR requires that a data subject has a right to request that you expunge records you have on them. You know, and this, if you leave this to be a manual process, it will be tenuous. You cannot really easily identify systems or business processes that have personal data on a data subject who's triggered the right to be forgotten. You know, other considerations include the fact that some laws that apply to the business may require you to keep certain records for a given period of time. So the right to be forgotten in such cases does not override your obligation to comply with other laws on record retention.